Welcome. My name is Cary Coglianese, and I am the director of the Penn Program on Regulation. And I'm delighted to welcome you to today's webinar, which is organized and sponsored by the Penn Program on Regulation, as well as co-sponsored by the Quattrone Center for the Fair Administration of Justice at the University of Pennsylvania Law School. I'm delighted to welcome you to our webinar today on how judges can make a difference in the success of supervised release. We will be hearing from the Honorable Judge Richard M. Berman of the U.S. District Court for the Southern District of New York, and the Honorable Judge L. Felipe Restrepo of the U.S. Court of Appeals for the Third Circuit. I would like to encourage audience members who would like to ask questions to enter those questions in the Q&A function on your Zoom screen. And I will be moderating the question and answer period with some audience questions, as many as I am able to get to in the time allotted. Let me start with the importance of this topic. It is a topic of criminal law and the criminal law system, which has historically dovetailed with the study of regulation. There's been a long-standing connection and overlap between criminology and regulatory studies in the academic world. And in many respects, the topic of our conversation today, supervised release, is a type of regulatory system, a way of overseeing those who have been incarcerated as they make their transition back to the community through a process of oversight and review of their behavior. We are very much interested in this conversation because the quality of our legal system overall also affects the quality of what other aspects related to regulation the legal system interacts with. We have two extraordinarily dedicated judges here who have initiated programs to provide more active judicial oversight and involvement in the process of supervised release and the reentry to the community. So I'm really delighted to have us here today to talk with judges. I want to start with Judge Berman. I'll introduce him, and then he'll offer some opening remarks, and then I'll introduce Judge Restrepo. Judge Berman has been a U.S. District Court judge since November of 1998. He's currently on senior status. A graduate of the NYU Law School, he also holds a Master of Social Work from Fordham University and received a Diploma of Comparative Law and Diploma of International Law from the University of Stockholm. Earlier in his career, Judge Berman was a lawyer at major law firms, Davis Polk and LaBeouf Lamb. He served as an executive assistant to U.S. Senator Jacob Javits. He also worked as general counsel to Warner Cable and to MTV Networks, and served as a New York State family court judge for Queens County. Currently, he's the chair of the Southern District Senior Judges Committee. He has served as an adjunct professor at New York Law School, is a member and has been a member of the New York State Permanent Judicial Commission on Justice for Children, and a member of the New York City Mayor's Child Welfare Action Group. He is a recipient of the National Association of Social Workers Emerald Leadership Award. We're really delighted to have him here. The one part of his bio that I haven't mentioned is that this summer he submitted, and we published here at the Penn Program on Regulation, an essay by Judge Berman on his supervised release program. We published that in the Regulatory Review, which is a daily online publication about all things regulatory, published by the students here at the University of Pennsylvania Law School. So Judge Berman, we're really delighted to have you here. We were delighted, obviously, also to publish your work in the Regulatory Review. Wonder if you could start off by giving us an idea about how your active involvement in supervised release takes place, and what you have learned from the last 5 years or so when you have been engaged in this more active approach to supervised release.
Let me unmute. Can you hear me all right?
You're great.
Great. So first, thank you so much for the kind words. And also really thank you for inviting me to participate in this, I think, enormously important subject. And also thanks for having me along with Judge Restrepo, who in many respects is the founding father, particularly of the Eastern District of Pennsylvania Star Court, which is the gold standard of reentry courts. If I might, because I think the topic is so important and I don't want to leave anything out, so to speak, I'm going to mention what I think are the key points of this subject, and then go into some more detail, certainly if there's time. First, I do want to acknowledge again Penn, the Penn program on regulation has been very supportive of me and of this topic, this important topic of court involvement in supervision, and also to the staff of the regulatory review. I'm honored to have submitted and have published a paper on this topic. The next point I want to make is that, and we'll explain, that court involvement in supervised release, in my opinion, reduces recidivism dramatically, in fact. And next, that court involvement in supervision is cost effective, and again, dramatically so. The next point I want to make is that conclusions that I have drawn come from a study, as you point out, Cary, a study population that we put together in chambers of my defendants, 152 supervisees during the period 2016 to 2020. And the purpose of that study population and the study was to figure out, if we could, what impact it was having doing court involvement in supervision. The way I do it is solo, so to speak. It's just as an individual judge. I take all of my defendants and put them through a program which I think has achieved some considerable success, and I'll explain in more detail in a moment. This work, I think, is challenging. It's also the most rewarding judicial function I think I've played as a judge over 25 years, including family court. And finally, the point I don't want to leave out is that in my estimation, when I first started doing supervised release court involvement, I selected a smaller group of defendants than I had, just to figure out a method and a process that was comfortable for me and that I thought was effective. But now I think, and now I have all of my defendants who come back as supervisees in the study population and in the program. So again, I'm really appreciative to Penn for their support for not only court-involved supervision as I might do it, but also as is done through reentry courts. And we too in the Southern District of New York have a relatively new reentry court. It's patterned, as all of them are, on Judge Restrepo's court, a reentry court and substantial program in Pennsylvania. So I'm going to get in a moment to the how I do it and or what I do, but I want to mention for a moment the very important topic of recidivism, which is a primary mover for preventing recidivism, which is a primary mover for the courts involvement in supervision, which is to curtail recidivism. And here, I have to say that, you know, in the United States, we haven't made so much progress, it seems sometimes, on reducing recidivism. There's quite a recent report, it's from September, from the United States Sentencing Commission, which reports on recidivism and which follows federal defendants who have been released from incarceration in 2010. And it had done a predecessor or prior report on federal defendants who had been released in 2005. And lo and behold, it is not a pretty picture here. The Sentencing Commission reports this time around that the recidivism rearrest rate remained unchanged, literally unchanged, as it had been for the federal defendants in 2005. So the 2010 showed no improvement over 2005. And here is the kicker, so to speak. The recidivism rate that it reports is 50%. It's astonishing. And the second significant finding is that those who were rearrested are most often rearrested within 19 months of the date they are released from prison. And I have to tell you that to me, it's just it's unacceptable. That's one word. It's stunning. That's another. I just hard for me to imagine that there would be no improvement at the federal level between 2005 and 2010. Now, perhaps when they get to 2015, there have been, you know, innovative projects such as the Star Court of Course, and work that people like myself are trying to do, and maybe there'll be some improvement. But it's just amazing to me that when I opened the report, I just got it about several weeks ago, to see those conclusions were shocking, in fact. So the problem of recidivism is by far has not gone away. I happen to think, and I think the evidence shows, that by court involvement in supervision, we are reducing recidivism. There's no question in my mind that's true. I think it's true in the Star Court, in the reentry court. It's true in my 152 defendant study population, and it's true to a dramatic, significant extent. So I think there's a low-hanging fruit here, as a matter of fact, is what it is. And I think that's why we are having so much success, because all of the impetus and desire, in fact, even on the part of defendants, is there. People don't want to reoffend. They don't want to go back to prison. They don't want to stay addicted to drugs. They want help. And if you provide all of that, which we do, those of us who are involved in supervised release, the recidivism numbers drop dramatically. So I wanted to make that point too. We have a big problem in this country of recidivism, and one significant, perhaps the most significant way we have thought of going about it is to reduce recidivism by the judge being actively involved in supervised release. I think you could state it in another way, and it's not over dramatizing, that as a society, in fact, we cannot afford not to implement court-directed supervised release, both at the federal level and the state level. and more broadly, in fact, one of the ways to do that is to encourage our colleagues, our other fellow judges, one way or another, whether it's involved in reentry courts or doing it on their own, to actively involve themselves in supervision. There's no doubt, sometimes from some quarters, there's a criticism of the defendants themselves for getting in trouble and getting in trouble again. I have no doubt, having spent all of this time working with these defendants, that they absolutely don't want to go back to prison, and they want help, and they need help in avoiding prison and avoiding recidivism. So the opportunity is there. I don't know if Anna is there. I have only 2 slides, which I think sort of demonstrate how much defendants are eager and interested in getting out of this conundrum of recommitting crimes. Anna, let's see. This is a quote. I hope you don't think it's over the top. It is a quote from one of the supervisees, and you'll see he says, "I'm not the same man." This is from a transcript, one of the hearing transcripts. "I'm not the same man who walked in here almost 7 years ago. I think if I had been left to my own devices, I would be dead right now. I'm one of those addicts who doesn't know how to stop. I came in here broken, feeling hopeless, very much alone, isolated. Addiction will do that. And being put into treatment and being held accountable through random drug tests and through reporting to Your Honor and attending 12-step meetings, all of the things that I did, my therapist, my psychiatrist gave me a community of support that I was completely lacking. And here I stand today. I could not have envisioned that I would be here in this position today, a totally changed man. I'll just conclude that I'm extremely grateful." And I put that up there today because if you could see and hear the hearings that I conduct, and others, Judge Restrepo will recognize this, you hear this over and over and over again, how people do want to be helped, and how when help comes, you can have a changed man. And if we could show the next slide, and that's all I have are 2 slides. This is part of the court supervision process. It certainly is in my case, and it is the concept that is provided for by statute for early termination of supervision. It's pretty much up to the judge's discretion. I think the law says that they must have served 1 year in supervision before you can reduce the balance of the sentence of supervised release. And here you see in the blue column, which is my study population, for the period 2016-2020, we had 40% early termination of supervision. It's usually a year, can be 2 years. It's really up to the judge. But this is a very important tool that we have and that we use in the process. It's a reward and it's a carrot. And it says, if you do what we ask you to do in terms of your supervision, and you don't get into trouble, again, we will let you out of the criminal justice vice, so to speak. And that's very important to people, because you remember that by the time they get to this stage, they've already been in jail, sometimes a significant amount of prison incarceration. And then they have supervised release, which is not uncommonly, it's either 3 years or sometimes it's 5 years on top of incarceration. And they, and rightly so, you know, are eager to get out of the process. But in order to get this early termination, they have to do the right thing, so to speak. Cary, you'll tell me when my time is up. I have a comparator here. In this business, comparisons are very, I guess, fraught would be the word. Usually when you're comparing something, the other population is not the same size. It may not include the same elements, composition. It's very difficult to say that one study compared to another shows anything. I put that up there though, because it was the only data that I could find that had shown what percentage of early termination is granted in the United States. And if you remember, it was only there for a flash, but it's not even the same year or time period. So I'm talking 2016, 2020, and the study of the Administrative Office of the United States was 2008. So it's hardly comparable, but I thought the difference was so great that it might have some value, some significance. I'm concerned about time.
Okay.
You tell me when it's.
You want to wrap up for now, and
Okay.
then we'll have Judge Restrepo speak, and then we can open it up for a conversation.
That'd be great. So the just quick wrap up. I started doing court-involved supervision in 2011. We were trying to find our way. By 2016, as I say, we had this 152 person population in our study. And we started seriously looking at the data because we thought something really valuable was happening. And it really was. I think our outcomes, just as the Star Court and the Rise Court, the outcomes are easy to come by, as a matter of fact. And lastly, the only thing I'll say is that how I view my own job and my own role in this process is for me to first listen, for me to focus, for me to coordinate, encourage, reinforce, and follow up. And in doing those things, I think that I think the judge can make a significant contribution. Anyway, thank you very much. And
thank you,
I'll
Your Honor.
look forward to questions.
Very, very grateful to you for sharing what you've been doing, what you've been learning, and what you've been achieving by way of helping those who are subject to your supervision. I'd like to turn now to Judge Restrepo, who is a pillar of the Philadelphia community, a judge on the U.S. Court of Appeals for the Third Circuit since 2016. He's a graduate of the University of Pennsylvania and has his law degree from Tulane. Following law school, Judge Restrepo worked with the ACLU's National Prison Project. He also joined the Defender Association of Philadelphia as an assistant defender and then became an assistant federal defender in the Eastern District of Pennsylvania before practicing law privately. His judicial career began actually in 2006 when he was appointed as a U.S. magistrate judge in the Eastern District of Pennsylvania. And he served in that capacity until being confirmed as a U.S. District Court judge in the Eastern District in 2013. And as a magistrate and a district court judge, he helped create the Eastern District's reentry program that Judge Berman has already referred to, the STAR program, which stands for Supervision to Aid Reentry. And this was very much a leadership effort involving a range of community partners, including the Office of Probation, the Federal Defender's Office, and the U.S. Attorney's Office. He continued his ascendancy in the federal court system and became appointed as a Third Circuit judge and asked to be able to continue with his involvement in the STAR program. In 2019, he was awarded the Champion of Justice Judicial Recognition Award from the National Criminal Defense Bar for his role in developing the reentry court program. In September, he released an updated report on this program and noted how it has continued to thrive and receive national recognition over its 14-year history. As Judge Berman said, he is it's no exaggeration, really a founding father in this sphere. And we're really delighted to have you here, Judge Restrepo. Could you tell us, give us an overview of what is happening here in the Eastern District and what kind of outcomes you've been observing?
Sure, and thanks for having me, and thank you for the generous introduction. I just want to make it clear that I don't see myself as the founding father. The founding father really would be Judge Rice. He was the first judge in our district to start this work. I followed several months later, but he and I have worked in a very close partnership ever since. The STAR Court was founded in 2007. It was an initiative by the Board of Judges of the Eastern District of Pennsylvania to try to address recidivism, particularly violent recidivism in Philadelphia County. So the judges' target demographic were violent offenders who had served significant federal prison sentences coming home to Philadelphia. Since we started, we've had about 401 participants. And about 322 of those participants have graduated or are still in the program. I'm not going to get into all the statistics. They're there for you in the report. I think probably the most important statistic for our purposes of our discussion is the revocation rate. And we really have focused on revocation as opposed to the arrest dates or arrest recidivism, in that revocation is really a more honest statistic. In order for somebody to be revoked from supervised release, it suggests that a judge has taken a look at the case, there's been some due process, and there's been an objective review of the situation, and somebody is then taken off the street or revoked from supervision as opposed to just having been arrested. Our revocation rate is significantly lower than the control group. Our revocation rate for graduates is about 9.4%. The control group is about 30%. And the control group was studied by a statistician who's now a professor at Loyola. We are one of the only courts that has had a statistician on board since almost the founding of our program. And Professor Taylor has published several articles that have been peer-reviewed discussing our efforts. If you really have an interest in this area, I would recommend that you look up Professor Taylor at Loyola, at LaSalle, and follow her, look up some of her work. So I think the easiest way to explain the program is very different than Judge Berman's, in that they're not my supervisees. The cadre is broken up into two different courts. There's a Tuesday morning court, that would be my group, and a Wednesday afternoon group, that's Judge Rice's. We meet on alternate weeks. I visit with my participants every other week. We set the courts up that way to accommodate individuals' different work schedules. So if there's a conflict with work, in the mornings, they can attend the afternoon sessions. If there's a conflict with the afternoon sessions, they're assigned to the morning session. In order to get into our program, probation, think of probation as the gatekeeper. Folks are interviewed at the halfway house when they're released from the detention facilities across the country, and they come home to Philadelphia. We have a probation officer who is embedded at Kintuck, which is the halfway house that folks come home to in Philadelphia. If they qualify, if they grade out high enough on the PICRA, which is a tool probation uses to determine somebody's, it's their best guess, we'll say, in terms of their the likelihood of this individual violating probation or in terms of violent criminal histories. If you grade out high enough, you're offered an opportunity to participate in our program. Everybody that participates is encouraged and in fact watches a court session before they opt in. It's an opt-in program. The individual signs a contract. The contract, in essence, transfers their supervision to either me or Judge Rice, depending on which court they've been assigned to, for grade C violations. The more serious violations, the sentencing judge, the district court judge, maintains jurisdiction on those. The theory here is that a lot of the lower grade violations can be dealt with very quickly in the reentry context, and they don't linger until they have a more significant problem that is then brought to the attention of the sentencing judge. The individual agrees to participate, and that means that they will be seen either, if they're in my group, they see me every other Tuesday morning. And the off week, they're visited by the probation officer. On the Monday evening before I get together with my group, I get a report from U.S. probation that tells me what the individual participants have been up to since the last time we met. It gives me a nice overview as to everybody's status, as it were. On Tuesday mornings, I get together with the group, and the group consists of 2 federal prosecutors, a federal defender, the probation officer who's in charge of supervision, a law clerk in the building here who supervises the interns. She's also a professor. Our program has generated a course of study in terms of criminal justice issues, recidivism, and that's housed at Temple. The various law schools in Philadelphia all have students in the group. The students then morph into interns into one of the 2 courts, and they represent the participants in court. So a lot of the collateral consequences that are tethered to having a felony conviction are issues these folks have to deal with when they come home, and we try to support them in terms of providing legal assistance on issues such as traffic violations, restoring driver's licenses, custody disputes, identity theft issues. Really anything short of a criminal issue, we will provide legal counsel by way of our interns who are third-year law students. We've partnered with a bunch of law firms here in Philadelphia, and the students are then paired with a lawyer, and the student is allowed to participate in court under the third-year practice rule. It's a win-win for the law firms like it because they send their young associates to court in a mentoring role. The law students obviously like it because they get to participate in court proceedings, and they get to meet the participants and act as lawyers. Again, in order to qualify for our program, you have to have either a violent criminal history or a violent criminal, the instant offense has to be one of violence. We screen out, and I say we, probation, it's not Judge Rice and I, and it's not the district court judges. You can't be sentenced to our program. It's a program that probation decides who is going to be offered the opportunity to participate in our program. If you have a serious drug issue, there's a different court that you're funneled to that's run by Judge Strawbridge here in Philadelphia. If you have serious mental health issues, there's a front-end court that's run by Judge Hay here in Philadelphia. The courts that Judge Hay and Judge Strawbridge are coordinating are modeled after the effort that Judge Rice and I set up in the STAR program. Among the partners that, let me go back to a day in the life of reentry court. What I do in court is what I do in the pre-meeting is discuss each one of our participants and see how they're doing. If there's an issue that needs to be addressed, we try very hard to come to a consensus as to the best approach to how to help this person. And we basically roundtable every issue. I, as a matter of practice, speak last because I don't want people to agree with me. I want to see what everybody else is thinking. The dynamics are very interesting. Oftentimes the defender may take a more strident position than the prosecutors on any particular issue. Once we reach consensus, we then go to the next person. If they don't have any issues, it's a very quick conversation. This pre-meeting lasts about an hour. We then go to the courtroom. And in the courtroom, I call each individual to the lectern and have a conversation with them. And it's a very different sort of conversation than you would expect between a judge and somebody on supervision. It's not a scolding. It's typically a conversation where I try to find out what's been going on in their life over the last 2 weeks, emphasize the good work they're doing. A lot of this, quite frankly, boils down to a lot of positive reinforcement and the sense of community these gentlemen have. And they realize that they're not alone. The court provides a sense of community and a sense of hope that a lot of these folks wouldn't find elsewhere. And I think, quite frankly, that's probably the single most important thing we can provide. I mean, we help them with everything else: jobs, dental assistance, help them access benefits, help them with tutoring, help them really, we meet this individual wherever they need to be met to help them make a good adjustment back to being a productive citizen. But the longer I do this, the more convinced I am that the most important thing we do is give these folks a sense of hope. And they come to realize that there are a lot of people that really do want to help them and that do care about them. And I think by the time they graduate from the program, they see the criminal justice system from a very different lens than when they came into the program. And I think that can only benefit all of us. These folks live in communities, they have friends, neighbors, family, and their respect, as it were, for the criminal justice system, I think, improves having participated in the program. And I think there's a ripple effect to that. Some of the partners that we have are the Fox Business School at Temple University. They help our participants with financial literacy. We have a relationship with Drexel's cognitive behavioral therapy program, where our guys are offered CBT, which is really a wonderful resource. If they complete the CBT program, they're given extra credit towards graduation. I should have explained that the end game for a lot of these fellows when they start is they want to make sure that they can accumulate 52 weeks of good time or good credit with us. That puts them in a position to reduce the back end of their supervision by a year. It usually takes about 80 weeks for somebody to accrue 52 weeks of good credit with us. When they are eligible for graduation, we have a graduation ceremony, usually with a very distinguished guest speaker, and it's a big deal. And quite frankly, it's probably the first time a lot of these folks have been celebrated. And it's really a wonderful ceremony. They bring friends and family to the graduations. We have relationships with quite a few entities at Penn. One of the more interesting ones is with the School of Social Practice and Policy, where one of the professors at Penn really hosted a Shark Tank type program for our participants, and they pitched their business ideas, and it gave them an opportunity to meet folks in the business world they would never have access to otherwise. We have a relationship with the Philadelphia Housing Authority that's given us Section 8 scattered site housing vouchers, which are really a very valuable commodity. We have partnerships with Lawyers for Social Equity that run expungement clinics. The partnerships we've established really have been all organically grown. We have a fund that was endowed by one of our judges, Judge McHugh, who's a Penn alum. And he endowed that fund to provide emergency expenses for the participants. And a lot of people have contributed since then. We have engaged quite a few individuals from the Third Circuit. The Third Circuit, under the leadership of some of our chief judges, have all been very supportive of our program. They have, in fact, hired some of our participants to work in the clerk's office. And that really is a nice calling card when we ask other folks to consider hiring our participants. We can say that the courts have hired some of these folks. We have law clerk volunteers that the law clerks cannot act as attorneys, but they can help our participants with resume writing, in practice interviews for jobs. We have a very aggressive program to help our participants access all the public benefits they're entitled to in Philadelphia that is coordinated by law clerks. We recruited a lot of folks from the Circuit Executive's Office to provide tutoring. A lot of these folks need some tutoring to take the CDL, the commercial driver's license, or the GED exams. And quite frankly, we will find a tutor for whatever they might need. So at the end of the day, it's in essence kind of a very holistic approach to the reentry process. It's not always a garden party, folks. I mean, we do have our sets of frustrations and our failures, so to speak. And we have the tools in our toolbox. If things aren't going well, we can suspend their credit. We can give them a verbal, not a reprimand, but a conversation in court, and to suggest that they need to do better. We can confine them to a halfway house. We can put them on house arrest, and we can even send them back to the federal detention center for a period of days. I can't remember the last time I had to send somebody into the detention center. And recently we've had very few occasions to even use house arrest or the house arrest or the halfway house. During COVID, the program was a little bit different. We couldn't see them live. So what we did is the group meeting was held by Zoom. And then I would get on the phone and call each one of the guys individually and talk to them on the phone. It worked. It wasn't as, you don't develop the same relationship with the participants. And they don't, more importantly, they don't develop the relationship with each other. One thing we do is we try to emphasize the value of positive networking. And we incentivize that, as it were, by offering folks extra credit towards their graduation if they secure employment for a fellow participant. So it's a lot of the social skills that many of us take for granted that a lot of these folks really hadn't been exposed to. I agree with Judge Berman that this is easily the most rewarding thing I've done as a judge or as a lawyer. It's been a wonderful program. It takes a good bit of effort. And I'm very thankful for the support the EDPA has given us, the US Probation has given us, the judges have contributed in many different ways, the law schools, the law firms, a lot of employers that we've reached out to have been very generous, in essence, taking a chance on some of the guys that we refer to them. I keep referring to my participants as guys. About 90, probably 95% of our participants are male. And I think that's because of the target demographic. In my current group, there's one female participant who actually just had a baby last night. So we didn't see her this week. But the overwhelming majority of our participants are males. And I think that's really a function of the demographic we've targeted. So I'd be glad to take whatever questions you folks have about our program.
Great. Well, thank you so much, Judge Restrepo, and for all of your leadership in this effort. And we have a lot of questions here, so I'd like to turn to those now. Anybody else who would like to pose one can enter it in the Q&A. I'm going to start with a follow-on, Judge Restrepo, to your point about the way things changed in the COVID period. And one student observed that there are reports that during the pandemic, there has been an effort to provide parole for more individuals who are incarcerated than they might have otherwise been normal. Did you see an influx, and this is for Judge Restrepo and Judge Berman, did you see some kind of influx or increase in the number of individuals under supervision over the last 18 months or so? And Judge Restrepo, you talked about how that changed your interaction through Zoom. Do you think it changed, the statistics that you've reported more recently? And did it change how resources had to be allocated?
I did not see an increase in the number of folks being entering our program. I do think that COVID, in a kind of a strange way, enabled a lot of our guys to find work they might not have been able to find otherwise, because employees were really needed. Folks, there's a labor shortage out there. And I think a lot of our guys really took advantage of that. I know that they were all working during COVID, and we were presenting them with other opportunities. So it suggested that there were jobs to be had. And so I don't think it really had any impact on our statistics, but it's a little too early to tell, only because I'm not sure we're out of COVID just yet.
Judge Berman, do you have any changes that you've observed because of COVID?
COVID had an interesting impact on, so we went from live in the courtroom, which is what we used to do, to virtual, either Zoom or actually teleconference. We wound up doing a lot of teleconferences. They were unfailing in the technology, and two things that happened. First, it was much more convenient for the supervisees who had a million other things to do, the daycare, childcare, work, going to treatment, going to therapy. So it was much easier for them to participate. And that was also true, by the way, for the lawyers and everybody else. So we actually did in 2020, we did 194 supervised release hearings, which was exceeded any year we'd ever by far. But the more interesting, I thought, at least that was my perception, even though we were not in the courtroom, it somehow the conversation, and the conversations are not, as Judge Restrepo said, they're not your typical Southern District of New York highfalutin conversations with a lawyer saying, "Oh, don't answer that question. I'll do it for you." They got a chance, that is to say, the supervisees, to speak, and they spoke. And you got the impression, I did anyway, that it was very helpful to them to be able, A, to speak and say without, retribution, and B, to speak to the judge. Now, I am, in my process, it's a lot different, as Judge Restrepo said, but I'm the person who put them in jail. So on the first, it wasn't uncommon for the first session for them to say, "Oh, God, not you again." And they would say, I just served 5 years or 6 years because of you, et cetera, et cetera. And that would start a process of me saying that this is not what this is about. We're in a different ballgame now. We are trying to be helpful. I hope you'll see that as time goes on. And through these telephonic conversations, many, they did. And that was kind of amazing to me to see. And by the way, a professor from Washington Lee Law School said, "It was amazing to you, but it probably also had an impact on you just as much as it had an impact on them." And there's a lot of truth to that. I mean, first of all, I got to know and understand, I hope, defendants in a way that I would never have the opportunity. Beforehand, all you did was they came in, they got arrested, plea, or bail or no bail, but very often the next stop was ultimately a plea, then a sentence, and then goodbye. So you really didn't know that person who was going through that process. You know them when you go through the supervised release process, and somehow or other, I think that has a salutary effect. Anyway.
So this is a much different role for a judge. And I wonder, what do you say to some people who might be listening who would say, is this really the role for the judge? Or should this be for someone else? So what do you say to that, Judge Berman first?
Well, it's not typical, that's for sure. But as I say, I think I was conveying that it's the most important work that I've ever done. If to turn someone's life around, to see them make a statement, as we put up on the slide, we hear that over and over again, and more than that, to have someone really turn their life around. That's really very meaningful to me. It was not totally unaccustomed to me. Having been a family court judge for 3 years, it was probably more similar to the way that a family court judge deals with a case than a federal judge, to be sure. But I think this is where the action is really, and I think this is where we need to, and other judges too, need to devote more attention.
Yeah, I couldn't agree more. The system is broken, as Judge Berman noted earlier. I mean, the recidivism rates are ridiculous. And so it's a broken system. And I think it's incumbent on judges, when there's a broken piece of the system, to try to do something about it. And the back end of sentencing has long been kind of ignored. And I can't think of anything more consistent with the judge's responsibility than to try to contribute to fix a very big part of the criminal justice system it's really in need of repair. And I think that the sort of work we've been doing is at least a step in the right direction.
Well, I think judging from the kinds of questions that are showing up in the Q&A, you have a lot of folks who definitely agree with you. And it's very impressive what you both have been doing and what others involved in these efforts have been doing. And a lot of the questions really go to how to replicate this. Is this something that you think should be mandatory, for example? Should there be some legislation that requires a process like this across the board, or is it better to continue, in a sense, letting 1,000 flowers bloom, and those judges like you who are committed and dedicated and willing to go the extra distance to run programs like this, let them continue? Judge Restrepo?
I don't think you can force people to do this. And it's been my experience that the reentry folks that are willing to do it, it's a very personality-driven enterprise. And you need the right prosecutor in the room. You need the right defender in the room. You need the right probation officer in the room. You need the right volunteers. Nobody's getting paid any extra to do this, and it can be a good bit of work. So I think, I'm not sure what kind of legislation, what it would look like, but I'm afraid that if we force people to do this, it's not going to work across the board. I do think we should replicate it and make people aware that these sorts of programs work, and help people start the programs and offer whatever assistance we can to folks that are willing to take the chance. But forcing people to do it, I'm not sure that's the right way to go.
Judge Berman?
So in terms of federal supervised release, I think the statute pretty clearly says that supervision is under the district court. So I think you could say it's a responsibility the way things are right now. I don't know how it came about that we seem to defer the supervised release programs to the probation department. Now, they play a very crucial role, no doubt about it. But I think ultimately the judge is responsible. But I agree with Judge Restrepo. I think we would get further, and that's why I was so delighted to be in this discussion tonight, by raising awareness, even of our colleagues, more and more of what can be done. I know a couple of tentatively said to me, hey, let's have lunch and tell me how you go about organizing this thing, or, I'd like to try it, or something like that. Because the problem is big scale, and you really need a lot of judges doing a lot of cases with a lot of defendants in order to ultimately have a dent. I have a very brilliant former intern of mine who's now a professor at Stanford Law School, and I had told him about it, what I was doing, and he said, yeah, he said, every judge, every federal judge and every state judge should be doing this. This is part of their responsibility. So, but I think Judge Restrepo is right. You wouldn't force them. I think if they saw and understood, what goes on better and what impact it can have on recidivism, for example, I think a lot of other people would step up and say, I'll try it. And that's what I think might be accomplished as a result of tonight's conversation.
Judge Restrepo, you've been talking to judges for some years about this around the country. And what have you seen works when someone else takes an interest? How do you advise them? What are the keys that you try to give them as key insights about how to make this work?
To be patient. This isn't going to happen overnight, and you have to walk before you can run. We've been doing this for a long time. I mean, it's hard to believe we've been doing it for 14 years. And we also are more than willing to help in any capacity. Judges have come visited our court, and we've met the stakeholders, the probation officers, the U.S. attorneys, the DOJ reps, et cetera. So we have an open door policy. but I think it's really important to be patient with yourself and don't get frustrated quickly, because there are a lot of growing pains in getting a program like this running.
What do you think about the prospects of replicating this at the state level versus the federal level? One of our students highlighted the fact that many state judges are elected, and maybe the questioner supposed there's a greater degree of sort of risk of public disapproval if someone who went through a release or reentry program like this was seen to be rewarded, but then committed an additional crime.
I personally think that this is one of those situations where it's good to have life tenure, because you could see somebody running for office and somebody would thought to be too coddling of of defendants, etc. I really do. I mean, I mean that sincerely. I think this has to be, as Judge Restrepo was saying, it's got to be organic. People have to come to it on their own, really, I think. And I think that many more would if they understood it better, and if they perceived what the outcomes could be. Not to mention the costs, by the way. We haven't said how much money is saved by people not going to jail, and in the way I go about doing it in S.D.N.Y, it doesn't really cost anything. It's my time and my staff for sure, but the probation department carries the laboring oar in finding the therapist and finding the drug program, finding medical treatment, etc. So all of that, and I bring back the original defendant's lawyer instead of supplying a new lawyer, and the U.S. attorney who had the case also. So there's really not a lot of cost. There's a lot of cost saving if you can avoid reincarceration.
I know that in Pennsylvania they've tried this, but one of the nuances in Pennsylvania that makes it difficult to replicate this is that any significant sentence, the state judge loses jurisdiction over the individual, and he or she is then supervised by the state parole board. So the whole dynamic is very different. In federal court, the judge stays with the case. At least in Pennsylvania, that's not the case. So there's just, every state has nuances that they have to factor into the equation.
Well, we have quite a number of questions still that we haven't been able to get to. We are really nearing our ending time. I did want to note that several attorneys who have clients before Judge Berman shared questions with us and comments too. And I just want to read from part of one comment commenter who, and both of these attorneys who've written in have said that their clients have thrived under your supervision. But I think this is a nice way of thinking about what's happening in both of your programs. It gives this attorney says, gives a defendant the right mix of authority and empathy to get on his or her feet and move on with life. And I wanted to just end with asking if you had either, and you can choose either one story you want to close with of a success story or something you're particularly proud of, or alternatively, if you had one thing that could be done to help you and other judges who want to do what you're doing by actively supervising those who've been incarcerated, what would be the one thing that would really help support judges in these efforts?
All right, I sort of something I've said before. I wish it were more widely known, because the lawyers, by the way, I don't know who wrote in, but I think they're pleasantly surprised to see their client thriving, and to see him or her, it's mostly is him, in a situation where he's treated as an equal, as a person. And everybody is so surprised when that happens. It's different than maybe in the courtroom typically, but it's really important for the judge to understand that this is a person, the defendant, and for the defendant to understand that this is a person who's not out to get him. So that there's a whole evolution that happens there. And here's an interesting side. So I don't know. Again, I don't know who these lawyers are, but typically the defense lawyer and the U.S. attorney don't say much during these conversations proceedings. It's usually me and the person, the defendant, and the probation officer and the therapist. But very often, and then at the end, I'll say to the lawyers, well, the defense counsel, did you want to add anything today? And lo and behold, a lot of them will say, no, thanks, Judge. I think this is going just fine. And I don't, as long as that's happening, and as long as my client is with the program, so to speak, I don't have anything to add. And the U.S. attorney will have even less to say than that. They'll say, well, we're pleased. It's going in the right direction. Let's play it out. So the roles change there too. So whereas usually in that courtroom in a criminal case, it's the defense lawyer and the assistant U.S. attorney. They're the only ones who speak. And now they take a back seat and they turn it over to different kind of professionals. It's kind of amazing to see and how supportive they are in just doing that.
So transformative not only of the individuals under supervision, but transformative of the entire process and the interaction of the professionals.
Everybody, yeah.
Very much.
Judge Restrepo, yeah, we'll let you have the last word here.
Well, I would really encourage judges that may be listening now or sometime in the future to seriously consider doing this kind of work. There are a lot of people telling you not to do it. There are a lot of people telling you it's not part of your job description. There are a lot of people telling you that you really can't make a difference. And it's not true. You can make a difference. You should try to make a difference. And I assure you it'll be among the most rewarding experiences of your professional career.
Well, Judge Restrepo, I want to pick up on a phrase that you used earlier in this conversation, that the reentry program gives the individuals who are under supervision hope, and actually use that to say that I think each of you, through your leadership and your public service, I think can give all of us in society hope that that broken system can be repaired, that we can do better than we're doing today. And I want to thank you both for spending time with us here today, giving us that hope and that insight and the data and the experience to encourage other judges to pick up this kind of active, empathic approach to those individuals who've been incarcerated and who are making reentry into the community. And thank you, of course, also for your service to the bench as well. With that, I'm going to conclude our webinar. My thanks to all of the audience members and my apologies to the many of you who asked questions who we did not have time to ask. But thank you for being here, and we hope for a lot better in the days ahead for the criminal justice system. Thank you very much.
Thank you.